Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. Happy Tuesday to each and every one of you guys. If you guys could be so kind as to hit that like button on the way in so that we can get in this good algorithm. To those people that are just scrolling through YouTube, they can see that we are live and try to see what we are talking about. What are we talking about at this lunch break? We are talking about the never ending YSL trial. So I made a post earlier because I've been in and out of the trial because I mean, you literally, unless you just have nothing to do, I guess, it's almost impossible to watch the entirety of these hearings. And especially with this new judge is not playing any games with the time. She starts on time and she says 9 o'clock. You better have yourself in that courtroom ready to go at 9 o'clock because that's when she is starting. She doesn't take 5,000 comfort breaks. She has certain breaks throughout, but for the most part, they're going for hours and hours and hours. That's how it was yesterday. And before all of the fiasco happened, before the other judge was removed from the case, Judge Glanville, there was a character named Kenneth Copeland, who is also known as Lil Woody or Woody or whatever. And many of you guys have probably seen him around these YouTube streets because he's popped up on certain bloggers' YouTubes and he's got pictures. You know, he's just become some type of a star, interestingly enough. Well, he is on the stand right now and he is considered the quote star witness or one of the star witnesses. But I think what a lot of people are forgetting is that this is a RICO. Lil Woody's testimony is not the end all be all, in my opinion, when it comes to the state's case, even though it may have been a critical part as far as felonies, but you don't need your overt acts to be felonies in order for you to satisfy the part of the acts when it comes to the RICO. But that's a whole nother conversation. I just think this case has been totally sensationalized and it's also become a laughing circus. So people are forgetting the crux and the underlining, and they wonder why is the prosecution still going on? Because they believe they still can prove what they need to prove in order to convict. My issue with this case, well, I have several issues, but one of those is that it just really seems like people are forgetting that these are lives on the line. I understand it's good content, and I like, some good content as well. I also have a YouTube channel, as you guys see, so I love good content too. At the end of the day, as an attorney, it's about Thug and whoever else's lives, their lives are on the line, and they need to make sure that their rights are protected. And that's what this is about. It can be laughter and all of that, but at the end of the day, nobody on these YouTube streets are going to do that time. If they get convicted, it's going to be them. So it kind of is frustrating for me that some people are just taking it as a come up as opposed to what this really is. Now, what this is reminding me of, for those of you that have followed me for a while, is the Tory Lanez case. That is another trial that I covered in California, and I went to that trial on a daily basis because some people are like confused as if what Lil Woody is doing is unprecedented, and it's really not. So there was a lady, this was the Tory Lanez and Meg Thee Stallion case. For those of you that followed it, Megan's best friend Kelsey went to the police, did a whole recorded statement, had several statements. She basically pointed the finger at, she had a lawyer on the phone, a lawyer that was there. She had her husband, all of this, and did a whole interview with the DA's office. She basically blamed Tory. She gave all type of information about some bribery over money not to tell and all type of stuff. Gave a nice, thorough, coherent testimony. By the time she got to trial, she did the same thing, but she wanted to plead the fifth, and she ended up getting I think it was use immunity as well. And she got on there and did the exact same thing. She was, that wasn't true. I don't know. I don't recall. That wasn't true. I don't know. I don't recall. And the prosecution had to handle her. I think they did a little better job in California, but they had to handle her in a similar way. So this is not anything that is new where people say, oh, I lied the first time, but I want you to believe me now. And as you guys see, Tory right now is locked up for a number of years because they believed what Kelsey said, even though she got on the stand. They were able to admit the testimony related to, well, not the testimony, but the statement that she gave the police prior to. And when the jury was deliberating, I was in the hallway, and one of the things that the jury asked was, could they see her first statement again? They wanted to look at it again. From that point on, that's kind of when I knew, I was like, oh, he about to be found guilty, because they believe what she said. So just because he gets on the stand, see what is happening is those that want Thug and all the rest of them free, they're saying, oh, he lied the first time and he's telling the truth now. The jury probably don't know none of these people, and they're going to look at the credibility of it. So I'm curious to know at what point they're going to try to call perjury. That's why I think for them to pigeonhole themselves and give him definitions on what perjury is was kind of like, why? Because perjury is what it is. I think it's self-explanatory. And obstruction. So I'm just wondering, like, how far they're going to allow this to go. But again, on the Tory Lanez case, they allowed her to get on that stand and do the exact same thing. If you saw that testimony, it would almost be like deja vu. It was the exact same thing again where she changed her mind. So no, this is nothing new. I am not shocked. But again, it's going to be the people. Basically, what you are asking the jury to do is say, ladies and gentlemen of the jury, I'm a whole liar. Okay. I lied every single time. And I chose to lie on somebody whose name is Thug. I'm a whole liar. I lied every single time I talked to them, and I implicated people. I just lied because I wanted to save myself. Knowing that these people may have ties to the streets or whatever it is, I decided it was safe for me to just lie on them. But today, ladies and gentlemen, I woke up, I am saved, sanctified, and filled with the Holy Ghost, and I know all 10 of them commandments. And one of those that sticks out is thou shalt not lie. So today, ladies and gentlemen of the jury, I am no longer a liar. I have been under the water. I have been baptized, and I am not lying anymore. So what I say today, where I say I don't remember nothing, I want you to believe I don't recall not a damn thing. Please just believe what I'm saying today and disregard everything that I said prior to. Now, this y'all the jurors. So this is basically what you're relaying that you want them to believe. So I want you today to just believe every single, even when one of the comments was, I think the prosecutor, ADA Hilton was like, asked him a question and he said, oh, basically that's cap. ADA Hilton said, well, what is cap? I don't recall. You just called cap, and now you talking about you don't even recall the definition of cap. I'm just saying, y'all, this is what they're asking. Am I making it up? Because that's pretty much what you saying, right? You saying, please believe everything that I'm saying right now. Disregard everything I said in the past, because today I just woke up and I'm here to tell the truth. I'm here to tell the truth now. So what I want y'all to do, I get it. It's so sensationalized that we just forget that these are jurors who are supposed to take the fact. If you were a juror and you were sitting in that jury in that box, would you really just all of a sudden be like, oh yeah, he's just telling the truth right now today? I believe everything he's saying, even the fact he barely know nobody's name. He doesn't remember what color the car was. He don't remember none of this stuff today. He don't recall. But he was just straight up lying when it was closer to the incident. Mind you, this was some years ago. These incidents allegedly happened. So now he was lying in, but he knows more now than what he did then. None of it logically makes any sense. So, but shout out to those that are ride or dies that's looking at it from a small little, looking at it like this, squinting your eye to make sure you find what you want to see. This is just the facts of it. I ain't got a dog in the hunt. I'm just saying. AK said, nope, I would think he's scared to tell the truth in public. And I believe that's what they thought about Kelsey in the Tory Lanez case. He didn't even remember his birthday yesterday. Do y'all hear this? He ain't even remember the day he was born. And it takes a lot more for a mistrial. And a mistrial don't help them. Because if you get a mistrial, you just starting all over again, which means that now things that didn't work, you're going to make sure you tune it up to try to make it work. The mistakes they made before, they're not going to try to make them again. Because even though this is taking a lot of time and resources, and I feel like perhaps it's time you may let it go if it was a mistrial, I think it's too many egos in this case at this point. I think they will retry it. I don't think they would just let it go. Then you got to start the clock all over again. They're going to try to get bond again. The judge may deny it again. And now you starting all over. So it's a mistrial. One thing that I can say that Thug's attorney was saying was like, he doesn't really want a mistrial. Unless it's something where you dismiss it with prejudice where they can't bring it back. That's not necessarily going to help the situation. Star Bill says she don't believe him now or back then. Okay. Destiny said, I'm pretty sure he's lying, but the case still hasn't brought anything to prove he's guilty. See, I didn't watch the whole thing, but I do know people don't understand what it takes for a RICO. That's what I'm getting from a lot of the comments. But I didn't watch the whole thing. You may be right. They may not approve the dang on thing. So I'm not a good resource for that because I just don't know. You know what I'm saying? Like I watched it on and off when fireworks happened, or I'll see a little clip down Instagram and I'm like, oh, that is funny. Let me go see what happened. Or when all these motions, when they were just like motions filed here and there, left and right and all of that. And then the judge want to send the prosecutor to learn about, do video learning, continuing education, learning as a punishment. I was like, Lord have mercy. So I watch when little stuff like that happen, but I haven't been watching it to that extent. So I just ain't the authority on it. I can admit when I am not the authority, but I can tell you from a general standpoint and being in similar situations that I don't know what. Woody is not all they need. All you got to do is you have to have other acts, and I believe it's at least 2, and they don't have to be felonies. So that is that on that. We'll continue to watch that. I don't recall. I did see it was pictures all up. I seen pictures on Twitter. I'm like, so we just posing with court report. What is happening right now? You know, and I know if that was in the hallways, you're not supposed to do that in the hallways. Like you can do it outside. Their depth usually is on your neck about that. But nonetheless, I'm gonna mind my business over here in Michigan, do my little cases. But I know when I was up there in that hallway, they were very specific on. That's why even when I took Erica King's picture, it was outside on the porch. Okay. It was outside of that courthouse. You ain't gonna catch me up. Ain't happening. Felicia said, I know one thing, Lil Woody is entertaining. He is. He very much so is. However, in theory, this is not a laughing situation. These are people's lives on the line. You got people that probably got kids. If not, they're somebody's sons, they're somebody's brother, they're somebody's uncle. You know what I'm saying? So if they are in fact innocent, as Brian still continuously says about his client, we want to make sure that the scales of justice are blind. We want to make sure, well, Lady Justice is supposed to be blind. And we want to make sure the scales of justice are weighed in their favor. So we don't want those, you know, we want a fair trial. Entertaining to us, but surely not entertaining to their pockets. And not entertaining to them going every day in that nasty Rice Street jail that they talk about. Some of them, I guess, are in Fulton and some of them are in Cobb County. But yeah. Yes. You said plus they are locked up without bail. Yeah. Yeah. So thank you, Pam. I was wondering how long he is going to be allowed to get away with I don't recall. Well, they told him, if you don't know, all you got to do is say I don't recall. So that's what he's doing. He's doing what they instructed him to do. But when I tell you this is so similar to what Kelsey did, it's almost eerily like, it's like, okay. I mean, this isn't the first time. So then we get the news. When I did my post and I was conversing with you guys back and forth on the post, get the news that Melnick, who is Woody's attorney, was suspended on today. I do have the Supreme Court opinion. It's very interesting because now, for those of you that weren't following, Melnick was the person that how Miss Bumpus got into this case, because Melnick was supposed to be representing Woody, but it was only a limited representation, meaning, according to what Bumpus said, Melnick was going to represent him just because he was going to plead the fifth and wasn't going to testify. If he chose to testify, then there was supposed to be a piece of paper that was signed, of which he was going to say, well, he doesn't have representation anymore. Well, all of this stuff happened with the ex parte meeting. Then it was another ex parte meeting and all this and that. And then when the judge recently decided, Woody was going to have to take the stand again, all of a sudden, I guess Melnick was back on the case. He said he was still his attorney. So once he decided that he was still his attorney, I know yesterday, I guess he was off in the gallery in order to observe Woody testifying. Well, today, which is very interesting because we went over the Christina Peterson situation and she has some stuff pending related to some disciplinary action as well. Like when the assault occurred, that she was accused of assaulting a police officer. It's very interesting that once the assault happened, a couple of days later, I guess she has some disciplinary stuff pending, and the Georgia Supreme Court made a decision on her as well. Well, with Melnick, he is a part of this case, and apparently there were some pending disciplinary issues going on. And this morning, the Supreme Court of Georgia, August 13th of 2024, they did an opinion on a disciplinary matter, and it looks like an old matter, so it is unrelated to this case. But the timing, of course, because this case is going on, everyone was like, and it became the headline. So, of course, when people were telling me about it, I wanted to look to see what it was because I knew it would be an opinion. And so we have what the accusation was. So the disciplinary matter is currently before the court on the report and recommendation of the State Disciplinary Review Board, which recommends that Jonathan Melnick be given a public reprimand and undergo a law practice management assessment based on his violation of Rules 1.3, which provides, we'll go to the footnote. This is Rule 1.3 says a lawyer shall act with reasonable diligence and promptness in representing a client. Reasonable diligence, as used in this rule, means that a lawyer shall not, without just cause to the detriment of the client, in effect, willfully abandon or willfully disregard a legal matter entrusted to the lawyer. And Rule 1.4, which provides a lawyer shall promptly inform the client of any decision or circumstances with respect to which the client's informed consent, as defined in Rule 1.0 sub 1, is required by these rules, and reasonably consult with the client about the means by which the client's objectives are to be accomplished. So these are all of the Georgia rules of professional conduct. The review board adopted the findings of fact and conclusion of law of the special master Lorraine Dixon Moore, who recommended a 90-day to 6-month suspension for the reasons discussed below. We agree with the special master that a 6-month suspension is warranted. Now, let's be clear. You do get clients. What made me want to read this too was because you do get clients who just want you to turn water into wine. This is why people will wonder why there are clients that I turn away, because some people have higher expectations. Or if I take their cases, I'm like, I'm gonna need you to put this in writing that I told you, Blase, you're not gonna become a millionaire off this case, or I told you, da 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 da. Because you do get some clients who will try to grieve you, and there's no reason to grieve you. And sometimes a lot of times, you'll get notice that it happens, but then they'll close it almost before you, as soon as you get noticed, because they can tell that something is going, tell that, this is just somebody who mad trying to jack up your livelihood because they don't like you or whatever it may be. So that was one of the reasons why I was like, well, let me go look and see what the allegation is and why they imposed this. But let's go on and read. Factual background. So these are the alleged facts. The following facts were either found by the special master or were established without dispute at the hearing. So there was an actual hearing. Melnick has been a member of the bar since 94. So he ain't new to this. He is true to this. He received 2 investigative panel reprimands in 2003 and an investigative panel reprimand in 2006. All 3 matters involve violations of 1.4 and 2 involve Rule 1.3. In May 2017, Melnick began representing the client in a matter filed in Rockdale County by the father of the client's child. The father was paying child support via an income deduction order and was seeking a reduction in child support, as well as to legitimate the child and obtain visitation. So probably get a paternity test so they can get visitation. During that time, Melnick was a solo practitioner with no full-time staff and no case management software. He handled between 50 and 80 cases at any given time and was in court 17 out of 20 days each month. Good gosh. Yeah, he was out here working. By himself too, without an assistant or a secretary, that's a lot. He used a software program to manage his calendar and communicated with his clients primarily after typical business hours. In March of 2018, Melnick, his client, the father, and the father's attorney participated in a voluntary mediation where the parties were able to reach an agreement on a reduction in child support. So they did a mediation. They were able to come to an agreement to reduce this person's child support. However, the parties still needed to agree on visitation and prepare a parenting plan. The parties agreed that the father's reduced child support payment would become effective April 1st, 2018, and that if a new income deduction order was not in place by April 1st, 2018, Melnick's client would reimburse the father each month for the difference between the child support amount paid pursuant to the income deduction order and the reduced amount agreed upon at the mediation. After the mediation, the parties notified the court that they had reached a settlement and would be submitting a final order, so the court removed the case from the trial calendar. The father's attorney emailed Melnick, so he was representing the mother, for those that wanted to know. The father's attorney emailed Melnick a draft consent agreement about a month after the mediation and asked that Melnick's client begin reimbursing her client for the child support overpayment. So, as you guys seen, according to this, there was an agreement that if the order was not in place and the father is paying, say, $500, but now it's reduced to $200. Now the mother is supposed to be like, okay, I got the $500, I'm gonna give you the $300 back because we already came to this agreement. So, almost a month later, Melnick responded, "Please call me." The two attorneys exchanged a few emails during May and June about a visitation schedule and the amount of the reimbursement. In early August, the father's attorney sent Melnick a revised consent agreement with the parenting plan included. A week later, Melnick responded that the parenting plan was fine, but that he, quote, was not going to agree to refund of the child support since April. The father can take that up with child support, end quote. Well, my. So, the following day, a Friday, Melnick emailed the father's attorney that he believed that it would not be proper for his client to send the reimbursement to the father's attorney. The following Monday, the father's attorney filed a motion to enforce the settlement agreement. So basically, the father's attorney was like, we have this settlement agreement. You signed it and I signed it before we left. And so if you're not going to abide by this agreement that we came up with in the mediation, then I'm going to file what's called a motion to enforce, which is to have the court make you abide by this, which would obviously include you reimbursing for the overpayment that my client has paid. Then the motion also saw an award of attorney fees for having to file the motion. So then you can also request that I shouldn't have to file this. You should just do what we agreed to and be a person of your word. And if not, then I'm going to ask you to pay my attorney fees that are associated with me having to file this motion. Melnick did not send his client a copy of the motion or otherwise inform his client about it. So he didn't send his client the motion to enforce at all. He also did not file a response to the motion because he felt it was, quote, unnecessary. So not only did he get the motion and the client didn't know about the motion, according to this, he felt it was unnecessary to even respond to the motion. Melnick planned to handle the attorney fees issue at the hearing and believed he could prevail, quote, pretty easily on it. The trial court scheduled a hearing on the motion for January 8th of 2019. Melnick did not tell his client about this hearing. Because he had a conflict for the date, he emailed a conflict letter to the judge's administrative assistant 5 days before the hearing was scheduled in an attempt to comply with Uniform Superior Court Rule 17.1. While the judge's assistant acknowledged receipt of the conflict letter, Melnick did not follow up with the court to determine if the hearing would be rescheduled. You said Woody is on live now, act clowning. Oh, Lord. He acting a fool in the hallway. Let me see. Is he on YouTube or he on Instagram? Let me see. Oh, Jesus. Wasn't he like Woody versus something? Oh, here he go. He on Instagram. Thank you, Patrice, for gifting 5 minutes. I appreciate that. Wait a minute. Woody.
Here, woke Christian.
You release.
Yeah.
Oh, shut your podcast out.
Okay. Hey, what's happening, people? It's Jason from Dear Woke Christian, hanging out with Woody, learning some new stuff about my man. absolutely down here supporting at the courthouse today. We had a good time. It's been a good conversation. So appreciate you. Check me out at Dear Woke Christian over on YouTube, and I'll let y'all there. But let me get you. But so yeah, I started doing a podcast, and I've been talking about this case, and a lot.
Say no. I'm not about to be watching that.
They talk about a case that happens to be somewhere around here, and I said, you know what? I'm at the house.
Anyways, okay, this stuff is unbelievable. Okay, let's go on. So basically, Melnick didn't follow up to make sure the hearing was rescheduled according to this. The court conducted the hearing on January 8th after Melnick was finished with the other matters for which he was scheduled to be in court on that day. He called the court and was told the quote hearings were done, end quote. He did not ask about the outcome of the hearing and did not contact his client to tell her he had not attended it. On January 15, 2019, the court issued a final order enforcing the settlement and ordering Melnick's client to reimburse within 30 days $2,820 to the father for child support overpayment, as well as pay $809.93 in attorney fees related to the motion to enforce. After the trial court issued the January 15 order, Melnick did not notify his client about the order, did not tell her she had to pay the $3,629.93 within 30 days, and did not send her a copy of the order. The client became aware of the January 15 order when, after the amount she was receiving in child support decreased, she went to the courthouse and obtained a copy of the order. That was also when she became aware of the January 8th hearing and motion to enforce. Melnick never filed a motion to withdraw from the case, nor did he terminate his representation. The client retained new counsel who contacted Melnick and raised the possibility of the client filing a malpractice action against him. Melnick discussed settlement with the client's new counsel, and after the client filed a grievance with the state bar, Melnick paid the client $3,500 and obtained a release. So the footnote says the testimony established that Melnick paid his client $3,500, but the record is not clear as to whether that amount represented a refund of the fees the client paid Melnick or was generally based on the amount the client was ordered to pay by the trial court's order on the motion to enforce. So this is the special master report. After the evidentiary hearing and consideration of the parties' briefs, the special master concluded that Melnick willfully violated Rule 1.3 and 1.4 and that his conduct harmed his client. The maximum sanction for a violation of Rule 1.3 is disbarment, and the maximum sanction for Rule 1.4 is a public remand. In addressing the appropriate level of discipline, the special master considered the facts and circumstances of the violation, this court's precedent in similar disciplinary cases, mitigating and aggravating factors, and the ABA standards for imposing lawyer sanctions. Then it has the case. The special master concluded that 4 aggravating circumstances applied, which were prior disciplinary offenses, a pattern of misconduct, substantial experience in the practice of law, and refusal to acknowledge the wrongful nature of his conduct. The special master also determined that 3 mitigating factors apply. Mitigating means it lessens the harshness. Aggravating is it goes beyond, adds to the harshness. So the special master also determined that 3 mitigating factors apply. First, she considered the existence of personal and emotional problems that Melnick said he suffered, although she gave this factor only some weight, noting that some of the circumstances Melnick relied upon as mitigating did not occur during the time frame in which he was representing the client, and that Melnick, who had been given an opportunity to submit documents after the hearing, did not submit any documenting supporting his testimony about having participated in counseling. So in sub 8, it says Melnick testified that he had marital difficulties for many years, had cared for both his parents through long-term serious illnesses, had ongoing health issues of his own, and had participated in counseling. At the conclusion of the evidentiary hearing, the special master invited Melnick to submit to her with a copy to the state bar any documents that would support this aspect of his testimony. Second, Melnick made a timely good faith effort to make restitution or rectify consequences. So this helped him. The fact that he said that he had some personal issues and difficulties going on, and the fact that he gave the $3,500 to the client. Finally, the special master recognized that Melnick had not received a disciplinary sanction since 2006. So he hadn't had any, it had almost been what? This was what, 17, when it, 10, over 10 years before he had ever had any disciplinary issues. The special master did not address Melnick's argument that she considers as mitigating factors that he lacked a selfish or dishonest motive, that he was cooperative with the disciplinary authorities, that there was a delay in the proceedings that was not caused by him, given that the formal complaint was filed 2 years after the grievance was filed and was based on events that occurred over 5 years ago, and that he was remorseful. Addressing the sanction that was warranted, the special master determined that a public reprimand was not appropriate and that Melnick's prior disciplinary history subjected him to an enhanced discipline. Instead, she recommended that Melnick be suspended for a period of between 90 days and 6 months, consistent with prior cases, such as in the matter of saga. It gives the list of all of the ones that kind of had similar disciplinary punishments. We can skip all those. Then we get to the review board's report. Let me see. You know what? Yes, congratulations to all of the new members. Love to shop 12. 12 said, Pam, thanks for the continued hard work. Thank you so much for the support. I appreciate it. Good vibe said they could have given them 90 days. You know, I've seen people that honestly they've gotten, well, that's here though. They've gotten just like your name will be listed in the publication as being reprimanded. But because I guess he had the prior one before, the courts, well, it was determined that it needed to be enhanced because just writing your name and say you were disciplined. And oftentimes attorneys will consent. So they won't even go through this hearing process. They'll just be like, yeah, I was wrong. And then try to agree and come up with a consent agreement where they don't, you know, so maybe you can try to get them to agree not to suspend you, but perhaps they'll just put you on there like they were formally reprimanded and they actually just put it in ink that you were reprimanded. But yeah. Melnick filed a motion asking the review board to review the special master's report. He contended that he did not violate Rule 1.3 and that in any event, a public reprimand was more appropriate. See, that's what he's saying. See, I didn't read that, but that's what he's saying. Like, just public reprimand me, meaning you just put my name in there and say I was reprimanded, but I still get to practice, you know, as opposed to being suspended. The review board concluded that Melnick violated 1.3 and 1.4, adopting the special master's factual findings and conclusions of law in all respects, except with regards to the consideration of Melnick's prior disciplinary history as an aggravating factor. The review board stated that it, quote, discussed at length, end quote, the prior disciplinary history and believed that the more than 15-year period since any prior disciplinary history should not only mitigate, but also should outweigh the extent that the history is considered an aggravating factor. It also disagreed with the recommended discipline and recommended that Melnick receive a public reprimand, which it concluded was consistent with prior cases, such as in the matter of Pagano. So this long footnote says the review board stated that the case should be reprimanded to the special master for her to state, quote, an exact and specific punishment, end quote, because they had not been able to find any past recommendations of a range of punishment by a special master in a contested disciplinary case, and because the special master sat, quote, in the best position to recommend a specific sanction, end quote. However, there is no need to remand to the special master because no additional fact finding is necessary in this matter, and this court exercises the ultimate discretion in disciplinary proceedings. So, you know, like the special master gave a range of like 90 days to 6 months. So they're saying the review board was like, can you like give us a specific time? But then the review board also felt it should have just been a public reprimand. Supreme Court said, well, we got the final say, so we don't even need to go through all of that. We just come up with our conclusion. Okay. So they also came with a bunch of case law as well. The review board did, and basically saying, let's go over a few of these cases or whatever that they went over. They said in the matter of Pagano, they accepting a petition for voluntary discipline and imposing a review panel reprimand for attorney who violated 1.3 and 1.4 had 2 prior disciplinary actions. And there was no indication that attorney took any steps to ensure the client was made whole. So basically, this person seemed worse than Melnick, and they only got public reprimand than what Melnick was accused of. And but see, they say voluntary discipline. That's what I was saying. A lot of times I've seen it when you've consented and not went through the whole hearing. But anyway, in the matter of Shapiro, they accepted a petition for voluntary discipline and imposed a review panel reprimand where attorney who was the subject of 2 formal complaints after having been disciplined 3 times within the last 9 preceding years made efforts to make aggrieved parties whole and lack a selfish motive. So they had their own case law, which would have went that Melnick probably should have been, according to the review board, just publicly reprimanded. He didn't need to be suspended. That's what the review board said. So now we're going to get to the parties' arguments. So, okay. So the judge found him a new attorney. They are having to get him to come to the courthouse now. Okay, cool. So Woody just announced in court that he does not want to testify any further without his attorney. I don't understand why he ain't do that in the beginning. That was my whole point. I asked Tracy, you on here? I DM'd her. I'm like, so did he say that he don't want to testify because now he doesn't have an attorney? Because Melnick basically said that, Melnick is not practicing right now. So now you don't have an attorney. So are they going to get him a new attorney? That was what my question was. Well, he's done all this testimony. So I wonder if now is this going to be an issue that he wasn't represented and didn't, and he still was on there and couldn't consult with an attorney because his attorney had been suspended the same day. Y'all think that's going to end up being an issue? Tracy said, I'm here, and he didn't say a word. Listen, did he not know he didn't have an attorney no more? I don't know. The case said, of course. Now he like, I don't want to testify until, which, oh, Lord. Too busy taking pictures in the hallway. Tracy said he knows now, I guess. Let me see. Did they come back on the bench yet? Or did he just say that on his live? Let me see. No, they're not on the bench just yet. I'm going to just put it on so it'll come on whenever they can't make this stuff up. So these were the parties' arguments. And its exceptions to the review board's report, the state bar asserts that the review board failed to adequately consider the differences in this case from the cases cited by Melnick, including that all 3 cases involve respondents who filed petitions for voluntary discipline in which they admitted to the wrongful nature of their conduct and were cooperative in the disciplinary proceedings. See, I didn't even read that, and I knew that. I'm like, yeah, there's a difference when you consent to it and don't go through this process. The state bar notes that Melnick, quote, never filed a petition for voluntary discipline, end quote, and failed to comply with discovery and the scheduling order filed in the case, which resulted in the state bar having to file a motion to compel, and that he has continued to place the blame on his client and minimize the harm of his actions. So they said since he just didn't admit and just go ahead and say I voluntarily be disciplined because I was wrong, you could have just got reprimanded. Darn it. The footnote said Melnick argued that his client did not suffer much, if any harm, given her testimony that with the assistance of a third attorney, she ultimately obtained an order in a related child support case, relieving her of the obligation to make the overpayment. So basically, she hired another attorney and she was able to be eliminated or being relieved of actually paying this overpayment. So Melnick is saying she wasn't harmed. I mean, she ain't had to pay it no way. So thus, the state bar contends that this case is more in line within the matter of herein, in which we held that, quote, a short suspension would likely be a sufficient sanction to make clear that the respondent and other members of the bar the importance of acting with diligence to ensure that the circumstances that led to misconduct are addressed before additional similar misconduct can occur. The state bar also argues that a suspension is warranted given that this matter is Melnick's fourth disciplinary proceeding and he caused harm to his client. In his response to the state bar's exceptions, Melnick argues, as he did before the special master and review board, that he did not violate Rule 1.3. In his view, there was no need to file a response to the motion to enforce because it did not seek any relief that was not already incorporated into the party settlement agreement other than the portion related to attorney fees. Moreover, while he acknowledges that the, quote, the better course of action would have been to file a motion for reconsideration as to the issue of attorney fees after the motion to enforce was granted, he states that he does not believe that the failure to do so constitutes willful abandonment. In addition, Melnick argues that his prior discipline was remote in time, that by paying his client, he has demonstrated his remorse, and that the payment should be considered as mitigating because he made it before the formal complaint was filed, and that the court should consider in mitigation his lack of selfish motive, his cooperation with the process, and the delay in these proceedings. He also asserts that the state bar contends that his failure to file a petition for voluntary discipline should lead to a harsher sanction, and argues that he is not in any way trying to understate his remorse or acceptance of responsibility, but simply believes that he did not violate Rule 1.3. He contends that attorneys have received, quote, much less serious discipline than what has been proposed here under similar circumstances where payments has been provided to the agreed party and there was a lack of selfish motive. And then he stated a bunch of cases for his argument. And then we get to what the court had to say. They make this final say. They had a conclusion here. Let me see. They ain't came back on the bench yet. I'm trying to look to see when they come back on the bench. Oh my gosh. Analysis and conclusions. We generally defer to the special master's finding of fact so long as they are supported by the record, but we review de novo the conclusions of law reached below on what rules were violated and what level of discipline is appropriate. Likewise, while we defer to factual findings, unless clearly erroneous regarding conduct that they may constitute a mitigating or aggravating factor, whether the facts constitute an aggravating or mitigating factor is a matter we consider de novo. Here go all of the cases. Having reviewed the record, we agree with the special master and the review board that Melnick violated Rule 1.3 and 1.4 by his willful failure to notify his client of or to respond to the motion and his failure to notify his client of the hearing on the motion or the entry of the order on the motion. Then it has case law. On the issue of mitigating circumstances, we agree with the special master and the review board that Melnick's personal or emotional problems are to be given some weight as a mitigating factor, and that the fact that he had no disciplinary sanctions for the 12 years prior to his misconduct in this case may be considered a mitigation. However, we conclude that Melnick's payment of money to his client is not a mitigating factor because he did not make any good faith effort to make restitution or rectify the consequences of his actions until after his client hired new counsel to investigate a malpractice claim and had filed a grievance with the bar. So basically, it's cool you gave the money back, but you should have gave it before she had to hire a new attorney, filed a grievance with the state bar and threatened you with a malpractice lawsuit. Okay, they coming back up. Let's see what's about to happen here. Hold on. Let's see what she gonna do. Let's see. Are y'all going back to the? Okay. Apparently, it was a false start. Let's finish. All right. Melnick asserts that this court should consider in mitigation that he did not act with a dishonest or selfish motive, that he was cooperative with the disciplinary authorities, and there was a delay in the proceeding given that the allegation at issue happened over 5 years ago, which it was. That was a long time ago. But the court disagreed. The special master did not make any factual findings from which we could conclude that Melnick's willful and knowing actions lacked a selfish or dishonest motive, or that there was a delay attributable to the state bar. Then they got more case law to back them up. Additionally, the fact that the bar had to file a motion to compel Melnick's response to discovery weighs against applying his cooperation with the state bar as a mitigating factor. With regard to aggravating factors, we agree that Melnick's substantial experience in the practice of law and his lack of remorse are properly considered an aggravation. Melnick's attempts to cast blame on his client and his characterization of any harm to her as, quote, very minimal reflects a lack of remorse. And then it gives the case law. We also agree that Melnick's prior disciplinary history, which involved conduct similar to the conduct at issue here, is an aggravating factor, but we do not give the existence of those offenses great weight, given that the sanctions were imposed 12 to 15 years before the misconduct in this case, and that there is no evidence of any disciplinary actions against Melnick for over a decade. Nevertheless, the existence of 3 prior disciplinary sanctions authorized the exercise of our discretion to impose a suspension or disbarment. Having carefully reviewed the record and the parties' contentions, we determined that a suspension is appropriate given that Melnick's misconduct was willful rather than negligent and harmed his client, and that he has received 3 prior disciplinary sanctions for similar conduct. We further determined that the mitigating factors do not outweigh the aggravating factors. Thus, based on the particular facts of this case and this court's prior precedent in similar cases, we conclude that a 6-month suspension is the appropriate sanction for Melnick's violation of Rule 1.3 and 1.4. Then it has the case law. Accordingly, it is hereby ordered that Jonathan Melnick is suspended from the practice of law in Georgia for 6 months. Then it has a footnote. Although the state bar asserts that Melnick has already completed a practice management assessment, citing Melnick's testimony that, quote, I did also do the law practice management course with the state bar, end quote, the record is not clear about when, if at all, Melnick participated in the state bar's law practice management program. If he has not done so recently, we encourage him to take advantage of this program and to adopt any recommended measures for the administration of the law practice. The suspension based on this opinion will take effect as of the date of this opinion is issued and will expire by its own term 6 months later. After the passage of time, there is no need for Melnick to take any action either through the state bar or through this court to effectuate his return to the practice of law. However, Melnick is reminded of his duties pursuant to Bar Rule 4-219 sub B. 6-month suspension, all the justices occur. So this was signed on today. So therefore, he was suspended as of this morning. So yeah, Woody don't have an attorney right now. Let me go back to this, see if they're going to come on anytime soon. Let's see. Woody is going on tour. Woody is going on tour unlimited me since he's been on this trial. He is making a mockery out of his trial and out of himself, and everybody's laughing at him with it. It's not funny right now. He had over 1,000 people over there on Instagram, so Florida T-Bird said, this is crazy. There's something with this case every day. It does. This is crazy. They came back, but took another break to get his new attorney. They found him a new attorney quick, didn't they? So how long is it gonna take for them to get a new attorney? Like they didn't know that he was suspended or something. Did everybody just find out this happened or something? Why are they just now trying to get him an attorney? Help me out in this chat. Like, why are they just now doing this? Did he not know this morning that he didn't have an attorney anymore? He didn't see his attorney in the gallery, did he? Let me see. You think he got Kayla Bumpus? You think so? Well, he's off alive. He's not on here anymore. And it doesn't look like he saved it, so. Oh, he up here. Look at him. He got the pictures. Got his new little fit. He up there. Look at him. Y'all see this? That look like a bench in the back. That looks like the hallway to me, but hey, who am I? Look who my new lawyer is at Sadie Nash. Okay, let me see. He put hood lawyer. I just went to his thing. I'm so confused. If he gets Kayla, he's going to be in trouble. She didn't represent herself well on the stand. The judge said it was just brought to her attention, so I guess everybody just how everybody find it out right now. It was all like, so what are they gonna say? We would like to strike all of his testimony from this morning because he was unrepresented the whole time. What's about to happen now? Because how did all of the YouTube streets knew all about it, putting it in the chat? Y'all told me. Shoot. I was like, oh, let me go look it up. The intellects told me about it. So how were they knew about it, but the judge and none of the lawyers knew about it? Y'all got to be kidding me right now. Karma said, I'm just as confused as you as to why they didn't know. YSSD said, where are the boundaries? Court personnel and attorneys hugged up with the star. I have never seen nothing like this ever in my career. I ain't saying I done practiced 1,000 years. I ain't old enough for that. But I haven't. That's very interesting. It's a very interesting situation. Tracy said we work in the law offices of Hood and Ghetto, so we know all. Listen, you guys over there at law offices of Hood and Ghetto are doing better, apparently, than those that really are supposed to be out here practicing. Like, how y'all didn't know this? I'm confused. Just Eb said that he even know. Well, an hour ago, he said he put that somebody else was going to be his lawyer. I don't know if that was really going to be his lawyer, but it sounded like he at least knew that. It's a Hood and Ghetto courthouse. Cece said the papers you read in him being suspended was live on Atlanta news station this morning. Exactly. Because I think when I asked, when they were, okay, so the first comment was somebody said the YouTube streets is saying that Melnick is suspended. And I was like, what? Where you hear that at? So then they said it was from 2017. So honestly, at first I was thinking, oh, that's old then. Like, so it was 17. I didn't think 7 years later, it still was an issue because usually they'll handle that within a decent, reasonable amount of time. Then I was like, well, let me go look at it. Then somebody said he got suspended for 6 months today. I'm like, huh? So then that's what made me look it up. And I was like, oh, that literally just came down this morning. But a lot of the news were, and then somebody did mention that on Atlanta, live on Atlanta, or one of the Atlanta news, they were talking about it. So the date on the paperwork is today, August 13th, 2024. Literally.
I'll tell Mr. Copeland this in a minute, but the attorney is happy to help, but not available until the morning. So I'm going to pass along his contact information, Mr. Copeland, and they can plan to be here in the morning. Question for the state. In the meantime, do you have any witnesses that you could get here that are, you know, like hour-long witnesses whose place in the story does not really matter that much? Like, I think you had some people listed as records custodians and things like that. Any chance we could fill the day with something useful while we've got the jury here?
The two witnesses that we did have on that were similarly situated. They were Mr. Slade, whose attorney left town yesterday afternoon, and Mr. Zachary, who said that he is in North Carolina.
Right. So what I'm asking is there a chance you can take some witnesses out of order who aren't integral to the progression of the story that you're telling, but whose testimony you need to get for, you know, whatever reason? Like, you've got some phone record custodians, which I don't know why y'all can't agree to that coming in anyway without a witness, but people like that.
So, Your Honor, the records custodian, for the records that they have to bring in, we do not have business record certs. And so,
Okay.
in prior discussion, I believe that the defense were going to object to those records without having the custodian. Those custodians are out of town, Your Honor. And so we would need time in order to.
All right. So it sounds like then that we're just going to have to release the jury for the day and pick back up in the morning with testimony, which doesn't mean y'all are all getting released. Maybe we can get some non-jury things done for the afternoon. But let's get Mr. Copeland in here. I'll give him this contact information. Then we'll get the jury in. I'll release them. Come on.
The judge is looking disgusted. You gonna waste half of my day? This is a whole 4-5 hours that's about to be wasted. This jury is like, it's on TV. You know that I'm playing this same thing right now on the screen. I'm actually playing it. So we heard when the judge said that they were gonna release them. You said a hot garbage mess. Pam, you looking like what in the Sam is going on here? I'm trying to keep up. I want to be able to keep you guys informed, but I think I'm more lost than you guys. You guys watching it more than I am, because I was just confused why he was on the stand, and I knew his attorney got suspended today. And it's when you get the opinion, it's immediate the day of the opinion. So I'm like, now he just I mean, he wasn't saying much. I don't recall. But Shirley divorce papers said prosecutors sick. They are horrible. Love and Hilton. Y'all have nothing on these men. Let them go. Y'all wasting taxpayers' money on bull crap. Fire these two. Well, dang, Shirley divorce papers. How do you really feel? My. Oh, okay. Yes. Sorry. I didn't get that as a question. I thought you were watching it separate and didn't know we were watching the same thing. Yeah, they're sending the jury home for the day, it sounds like, because they didn't have any other witnesses lined up or ready to go. I thought they would, because it really wasn't definitive whether Woody was going to testify. We didn't know that until yesterday when he took the stand that he was going to even testify. No, they don't need me. Y'all couldn't pay me to drag me like y'all drag these other judges and lawyers. Y'all not doing that to me. Like, cause I'll be a part of a system, then I just get blamed by default. You're not doing it because you guys like to generalize
All
using
right,
the word
Mr.
like
Copeland,
all.
during the break, I was able to speak with Mr. Engelberger, and he is happy to represent you. I've got his name and his phone number written down on this sheet of paper, which I'm going to provide to you, and you can call and speak with him this afternoon. And he is available beginning at 8:45 in the morning. So what we'll do is plan to pick up there tomorrow with you and with him available for you. And in the meantime, between now and then, you go ahead and give him a call and y'all can talk about whatever you need to talk with him about. Okay. All right. So we'll see you at 8:45 tomorrow.
You give me enough time to talk with him?
Yeah, you can talk with him for the next.
Oh, it's not today?
Yeah.
Oh, so he's
Yeah, he's available today. He'll be waiting for your call.
I'm not gonna have any problem with him, is it?
I mean, I don't know why you should.
Okay.
All right.
You take care.
See you in the morning.
Be safe.
Okay, you too.
Hello.
All right, let's get the jury in, and I'll excuse them for the day until 9 tomorrow.
That's what it sounds like, that they assigned him a attorney with the court. I think this is him. I'm not sure. The Engelberger Law Group. Did she say his first name? If this is the same one, they practiced for almost 20 years. You would love to be, would you? And not work for the next 2 years? You would love to be a juror on here? That's interesting. He's a public defender. Okay.
Thank you. Well, ladies and gentlemen, we have had a little bit of a scheduling and procedural hiccup, I guess. So I am going to need to release y'all for the day and have you come back at 9 in the morning to pick back up. We're going to stay and get some other work done, but I'm going to release y'all. I'm going to remind y'all that you are to only decide. We all good? Okay. Decide this case based upon the evidence that you hear in this courtroom. So do not try to find out any information from any source outside the confines of this courtroom. Do not refer to any kind of reference, either old school or online, to try to get information about legal terms, people, places, events, anything like that. Do not talk to anybody about this case. Don't let anybody talk to you about the case. We will see you all in the morning. Y'all have a good afternoon and evening, and thank you for your time. Sorry it was a short day today. Y'all are excused. See y'all at 9. Good. Okay, so state, I don't know what tomorrow holds. None of us do about this trial or anything else, but make sure that you've got some other witnesses lined up just in the event that who can get here quickly in the event that, you know, things take some other turn in the morning. Scheduling wise, I think I had mentioned yesterday that next week, I wasn't sure whether it was Monday through Thursday or Monday through Friday. But regardless of whether what they were told at this point, a juror has a family funeral that they have to travel for on Friday. I've confirmed that. So that will be a non-jury week in its entirety next week. All right. For us right now, I am hoping that there are some things that we were going to be doing next week that we can just go ahead and tackle today since we all are here anyway. So, well, I think Miss Love, you were, I think, the one that was maybe taking the lead on the PowerPoint issue. And I know you haven't filed a written response yet, but can you just kind of provide us with what your position is on that? And maybe we can make we, as in I, can make a decision on that issue.
So, Judge, what I said yesterday and when I was asking what was the need for the time to locate within the videos of those proceedings, the period that we addressed these PowerPoint. So I had received just some of the transcript of some of one of the days that we addressed it. And I think that we were addressing the PowerPoint in the context of other objections, maybe that there had been mounted to another witness's testimony. I think it may have been D'Angelo White. So the judge at that point had sort of responded to, it may have been commentary by Mr. Sharp regarding reviewing some evidence the night before. I may have these dates and these times to sort of conflate with one another, but I believe that when he brought up the PowerPoint, we had not yet argued it or talked about it.
Okay, I can't do it, y'all. I can't be listening to her arguing about this PowerPoint and all that stuff. But anyways, that's it. That's the Melnick. That's my take on the YSL for today. You guys can go on over there and watch them argue and all of that. We'll see what happens in the morning. If I'm up, I'll try to do Lil Woody's thing in the morning over here, but I do have something in the afternoon, so I would only be able to do it in the morning. But other than that, thank you guys for rocking with me. Make sure you hit that like button on your way out. Subscribe to the channel if you have not done so already. Jackson said Pam threw up that church. Listen, I ain't gonna be able to do it, okay? I was gonna sit here and try to hear about what they was arguing about next. But I can't do it. I gotta prepare. I got a deposition in an hour, so I'm gonna prepare for my deposition. And you know what, guys? I also have, for those of you, let me see, I got some audio from Kevin Hart with this whole Vegas scandal that happened. So I was supposed to do a live on that, but I don't know. I'll do that on here. I end up doing the audio in my membership. I'm not sure, but I should be back soon. This week, I'll be back. But I have a heavy week as well, so I just don't know when. So just be looking out. Make sure you got your notifications set so you can get notified whenever I go live and all of that good stuff. Thank you to all my mods. I appreciate you. To all the ones that gifted membership. Thank you, Patrice. I appreciate that again for you gifting the memberships to some new intellects to expand our community. And until next time, oh, I'll talk to you guys later. Have a good day.